Hi, my name is Hannah Hill. I'm the Policy Director for the National Foundation for Gun Rights. And I wanted to talk to you today about a ruling issued by the Fifth Circuit last month. So this ruling's gotten a lot of negative press. It's United States versus Rahimi, and there's been a lot of really kind of crazy headlines that it's generated. So I pulled a few of them here to share. So Hill Country News says, the court overturns federal law that kept guns away from people with restraining orders. Another one, appeals court ruling says that alleged domestic abusers have a constitutional right to keep their guns. And another one here, a court ruling puts domestic violence survivors in peril. Well, I wanted to take a few minutes to talk about the case and to discuss what it actually does, correct some of this misinformation and panic, and talk about why the case is actually a win for both law and order and for the right to keep and bear arms. So first, a quick overview of this case. So federal law prohibits you from possessing a weapon if you're under an active domestic violence restraining order. Now, a restraining order is a civil process. It means you don't have anywhere close to the same amount of due process protections that you would have in a criminal trial. That makes them easier to get and consequently easier to abuse. The same is true also of red flag orders, which also allow the government to strip away your gun rights based on somebody's opinion that you are dangerous. Now, Zaki Rahimi, the guy in the case, was indicted for possessing a firearm while under a domestic violence restraining order. He appealed that part of his sentence, saying that under Bruen, the courts can't actually take away gun rights just based on a restraining order. And the Fifth Circuit agreed, and so that part of the federal law is struck down as far as the Fifth Circuit is concerned. So naturally, everybody started panicking because obviously this has to mean that abusers are now able to have guns again. So let's talk about why that's not exactly the truth, that's not exactly the full story, and it's not nearly the cause for panic that the media and the gun grabbers would have you think. So let's start with the obvious. A restraining order is just a piece of paper. They only work if the abuser voluntarily complies. The people who most need the restraining, the abusers who are inclined to violence, aren't going to stop just because they're told to. And in fact, a lot of times it's going to make the situation worse. That's why many women in terrible situations don't even bother with getting a restraining order. Why? Because one, they know it's not going to do any good. And number two, they know it's simply going to make him mad. If you want to protect yourself in a bad situation, a gun is much more effective than a piece of paper. Now, the guy who brought this case, Zaki Rahimi, he was convicted of possessing a firearm while he was subject to a domestic violence restraining order. But they caught him due to the following. On December the 1st, 2020, after selling drugs to an individual, he then fired multiple shots into the buyer's home. The very next day, he got into a car accident. He shot at the other guy. He took off. He came back and then fired into the car again. 3 weeks later, he shot at a police car. And then a couple of weeks after that, he was at Whataburger with a friend. His friend's card was declined, so our guy fires multiple shots in the air. Now that part's a little confusing to me because I've actually been to Whataburger and I didn't think it was anything to write home about. Now, you Texans can correct me in the comments if you like. But all that to say, if you need the felony gun possession charge to put this guy away, you've got bigger problems than Bruen. And in fact, of course, that felony firearm charge, that was only one of the charges they got him under. He's currently in jail now under charges like multiple counts of discharging a firearm, assault, aggravated assault with a deadly weapon, possession of a controlled substance. They didn't need that to put him away. And if they had, it's not because the Second Amendment's at fault. It's because the laws dealing with criminal justice are at fault. Now, Bruen specifically stated that the Second and 14th Amendments protect an individual's right to carry a handgun for self-defense outside the home and inside the home. That is how the founders envisioned dealing with violent crime. Our lawyer has said in some of our assault weapons ban cases, the founding generation's solution for mass killings was not to deprive ordinary citizens of weapons needed for self-defense, but for armed citizens to have an active role in preventing or minimizing the harm caused by such killings. That's exactly what Bruen protected. Again, a gun is much more effective at keeping a woman safe than a piece of paper is. So, the Fifth Circuit did not say that you can't prosecute abusers. They simply said that you cannot strip away a Bill of Rights guarantee without due process, which is what our entire criminal justice system is protecting. So first, the Fifth Circuit Court looked at what the law does, and then they asked the question, is the text, history, and tradition of the Second Amendment consistent with stripping away gun rights based simply on your status as a dangerous person, as is determined in the protective order process, but is also determined in the red flag process in states with red flag orders allowing the government to strip away your gun rights just based on a hearing at which you're not even present. This ruling does not deal with red flag orders, but it's almost the same exact legal arguments at stake here, which is why another reason this ruling is so important. So here's what the Fifth Circuit said. Under the government's reading, in defense of this law, Congress could remove unordinary or irresponsible or non-law abiding people, however expediently defined, from the scope of the Second Amendment. Could speeders be stripped of their right to keep and bear arms? Political nonconformists, people who do not recycle or drive an electric vehicle. One easily gets the point. Neither Heller nor Bruen countenances such a malleable scope of the Second Amendment's protections. In other words, the government can't strip away a Bill of Rights guarantee just based on your status. If they think you're a dangerous person, they think you shouldn't have a gun, they think you're a domestic terrorist, they think you're a speeder, they can't strip away your gun rights based on that. They have to take your gun rights only when you have forfeited them under the law and as determined by a court through the due process protections laid out in our laws and Constitution. That's the way you do it. The due process protections required in a criminal court are not all present in civil proceedings. They're not present when you're getting a restraining order. They're not present in a red flag case. That's why you cannot use them to strip away constitutional rights. So the Fifth Circuit then looked to see if this law has a historical analog, and the answer was plainly no, because the founders crafted the Second Amendment to stop government from stripping away gun rights at will, just because the government may think those people are dangerous. So that begs the question, what about the people who are dangerous? People like Rahimi, people like criminals, people like domestic abusers who are making threats of violence against people. Well, Judge James Ho on the Fifth Circuit gave us the answer in his concurring opinion. And honestly, I'm just going to read you a couple of sections from that because I can't say it any better than he did. He says, I write separately to explain how respect for the Second Amendment is entirely compatible with respect for our profound societal interest in protecting citizens from violent criminals. Our founders firmly believed in both the fundamental right to keep and bear arms and the fundamental role of government in combating violent crime. And he went on to point out, those who commit violence, including domestic violence, shouldn't just be disarmed. They should be detained, prosecuted, and convicted and incarcerated. And that's exactly why we have a criminal justice system, to punish criminals and disable them from engaging in further crimes. And he went on to say this, the power to incarcerate violent criminals is not just constitutionally permissible, it's imperative to protecting victims. After all, anyone who's willing to break the law when it comes to domestic violence is presumably willing to break the law when it comes to guns as well. The only way to protect the victim may be to detain as well as disarm the violent criminal. And he also went on to point out that there are multiple ways that domestic violence restraining orders or just protective orders in general can be used for abuse and not simply for protection. He points out there are additional reasons why disarmament based on civil protective orders give us pause. Scholars and judges have expressed alarm that civil protective orders are too often misused as a tactical device in divorce proceedings, and issues issued without any actual threat of danger. That makes it difficult to justify this section of code as a measure to disarm dangerous individuals. And that this makes civil protective orders a tempting target for abuse. And I would add that that is also true of red flag orders. That's one of the reasons they're so concerning, not just because they take away a constitutional right without due process, but because they're so easy to get, and because there are no due process protections, they can be misused for political or vengeful purposes. So, in conclusion, he says this: we must protect citizens against domestic violence, and we can do so without offending the Second Amendment framework set forth in Bruen. Those who commit or criminally threaten domestic violence have already demonstrated an utter lack of respect for the rights of others and the rule of law. So merely enacting laws that tell them to disarm is a woefully inadequate solution. Abusers must be detained, prosecuted, and incarcerated. And that is what the criminal justice system is for. And he's 100% correct about that. That is why this was such an outstandingly good ruling. Now, it's possible that the Fifth Circuit will rehear this en banc. I certainly hope they don't, because this ruling does everything that it should have done, and is an example of what an accurate and good faith application of the Bruen standard to a Second Amendment case should look like. And again, if the laws don't allow you to deal with the criminals that need to be put away, change your laws. Don't violate the Second Amendment for everyone else. If you'd like to get involved with the gun rights fight, there's a link in the comments below, and don't forget to like this video and subscribe for more Second Amendment updates. Thank you very much for listening.